I'm Jay Inwald. For those who don't know me, I'm Director of Foreclosure Prevention at Legal Services NYC in our central office. So without really further ado, I'm going to just sort of launch into the presentation about standing. Just to talk to you about the materials that you've been given, first of all, before I get started, the PowerPoint itself is highly selective and is not necessarily comprehensive, but I've tried to include on it some of the really helpful decisions as well as some of the appellate division decisions that people want to sort of have available. The outline that's been provided is really not even appropriately called an outline anymore. It started out as an outline about 4 years ago, and it's grown so that it really just is a long, rambling memo, but it does have a pretty thorough collection of most of the important decisions. In an effort to update it, I didn't inject the recent cases in the body of the memo, but starting at page 20 of it, there's an actual supplement that basically covers the last year or so's worth of case law, and I've broken it down by circuit and trial courts. So hopefully that's somewhat helpful. I wanted to also just mention that my focus is sort of on the using standing issues in foreclosure cases, and I wanted to give it sort of a procedural context and suggest that people think about whether you're using standing defenses defensively or offensively, and what I mean by that is, are we using it to try to oppose a plaintiff's motion for summary judgment? Are we also trying to use it offensively to get the case dismissed for lack of standing? And I'll try to draw your attention to the tensions when you're trying to do both of those things, because often our strongest suit is opposing a plaintiff's motion for summary judgment by demonstrating that there are sufficiently disputed issues of fact concerning standing or the plaintiff's right to foreclose, and it seems there's a little tension if we're also cross-moving in the same context to actually get the case dismissed for lack of standing. But having said that, there's also a good precedent for doing that. So I'm not saying that that shouldn't be done, but I'd like to just sort of flag that as an issue. And that's going to be a judgment call in individual cases. The other thing I wanted to just sort of mention before we launch into this, why are we even talking about this? Like, why is this an issue? And is there any other area of law where you practice where there's even a question about why the plaintiff is the plaintiff in the case and whether that plaintiff should be the plaintiff in the case? Obviously, the reason for that is the way mortgages were marketed and packaged and securitized, because it's that whole background of securitization that has made it so difficult in so many cases for the plaintiffs to actually document their right to foreclose. And it's, of course, tied in with the whole subject of robo-signing, because so many of the documents that were robo-signed were the documents that are needed to establish ownership of the debt. Not to mention the fact that the complaints themselves were effectively robo-signed by foreclosure mill firms. So the other thing I, again, flag before we even get started is that an argument can be made, and there are now some judges buying into it, that we're not even talking about standing at all. What we're really talking about is whether the plaintiff can prove its prima facie case. So we'll get into that. And then the final point that I want to make, again, before we start, is that I can't really present this coherently because the law is largely incoherent, and I apologize for that. But I firmly believe that there's really a case to support almost anything you want to say. And we did a training a few weeks ago for the judges in Kings County, and just talking about the body of law in the second department, which governs Kings County, I basically told the judges there is support for virtually anything you want to do. So with that, let's get started. And I wanted to start out by, again, placing this in context. Is standing jurisdictional? For anyone who went to law school, you might think that it is. In the federal Constitution, there's a requirement that there be a case in controversy for disputes to be justiciable. And part of whether a dispute is justiciable is that the party prosecuting the claim actually has an interest in that claim. One might even think that New York has the same approach to standing. I put up on the screen language that I love to quote from Siegel on New York Practice, who kind of summarizes what the concept of standing is about. And he says, when one without the requisite grievance does bring suit and it's dismissed, the plaintiff is described as lacking standing to sue, and the dismissal is one for lack of subject matter jurisdiction. You would think lack of subject matter jurisdiction is kind of an important thing that would give some courts pause. And in fact, even New York's Court of Appeals, not that long ago, seemed to echo that sentiment. And you've seen this language cited for those of you who've been practicing in this area for a while. In many decisions, standing is critical for the proper functioning of the judicial system. It's a threshold issue. The road to the courthouse is blocked if you don't have standing. That sounds pretty hard and fast. But as it turns out, in New York, this is not an issue of constitutional dimension, and it's treated as an issue of common law. And when things are treated as an issue of common law, rules tend to get bent, and that's what we've seen happen. So again, I want to just focus attention on the distinction between capacity to sue and standing, and I'll get into why that's significant a little bit later, but it's a really important distinction to keep in mind. Capacity to sue is all about the status of the party, and does that have the ability to go into court. A foreign corporation or a limited liability company can't bring an action in New York State court unless it's filed necessary paperwork with the Secretary of State. That's capacity to sue. A minor can't prosecute an action in its own name. It needs a guardian to do that. A trust can't prosecute an action in its own name. It has to act through the trustee. And the state has to act through its administrator. Those are all capacity issues. Those relate to the status of the party. Standing asks about the relationship of the party to the claim that's being pursued, and is its interest in that claim sufficient for it to be able to pursue the claim. It's a really important distinction, and as I'll get to later on, it's a distinction that many of our appellate courts don't seem to be capable of really appreciating. And I urge everybody not to conflate these two issues. I often see answers put in where it's sort of lumped together as one defense, and I would really urge people not to do that, because I think it undermines our efforts to educate the judiciary. If we lump them together, we can hardly fault the courts for conflating them. So if there's a standing defense and there's a capacity to sue defense, they really ought to be recited as separate and independent defenses. So grounding ourselves in foreclosure cases, what does standing require? What do you have to demonstrate to establish standing? That's pretty much set. A foreclosing plaintiff must own the note and the mortgage at the inception of the action. Again, the note and the mortgage, what the note represents is the actual contractual obligation to pay the debt. That's the contract that's being sued on. The mortgage is just a way of documenting the security interest, the collateral for the debt. The mortgage on its own is a nullity. It doesn't represent anything. It's the note that you have to have. The money has to be payable to you to be able to pursue a foreclosure action. The assignment or the transfer of the note has to have been accomplished. If the foreclosure is being prosecuted, as it is in most cases, not by the original lender, but by some kind of transferee or assignee, that assignment has to have been completed before the action was commenced. This was This is a very basic requirement. It's well established by now. Assignment, as we'll get into, can be affected in various ways by a written assignment or by physical delivery of the note and mortgage. When we're talking about physical delivery, it's almost impossible for the plaintiffs to really prove that the physical delivery took place prior to commencement, and we shouldn't usually accept at face value assertions that that has taken place when the quality of the evidence that's being relied on doesn't actually establish that. If there's a written assignment, the execution date will generally control. Conclusory affidavits of prior physical delivery are highly suspect and can usually have holes poked in them. Backdated assignments are ineffective, absent proof of prior physical delivery, that's, again, that was an issue that was litigated for a long time before it was sort of definitively resolved, but that's very much done. It's been established by now. Again, here are some more authorities concerning the fact that retroactive assignments are ineffective. In particular, there was some question up until the Marchione decision from the Second Department when commencement of the case is measured from. The plaintiff there tried to argue that it's measured from the filing of the, from the service of the complaint, so that where they had executed the assignment after they commenced the action by the filing of the summons and complaint, but had not yet served it on the defendant, they tried to argue that they were still good. That was put to rest in Marchione, rightly so, because New York is a commencement by filing state. It's not measured from service of process. It's measured from filing. So we're not seeing that being an issue that much anymore, but it had been a pretty prevalent issue. Just to sort of point out what the major, the particular issues that we tend to see implicated in foreclosure cases generally revolve around the assignments and the chain of title, the timing of those assignments, suspicious endorsements and allonges, which we'll talk about as we get into some of the cases, assignments from MERS, Mortgage Electronic Registration Statement, the system as nominee, lack of documented authority of the parties who are purporting to sign assignments, assignees, in other words, those on the receiving end signing assignment documents on behalf of the parties supposedly making the assignments, obviously robo-signing of assignment documents. Another large category is the pooling and servicing agreements, which govern the mortgage-backed securities, which mostly took over ownership of these loans shortly after they were originated, have very strict and explicit requirements for when and how loans need to enter into those trusts. So there are non-compliance with those pooling and servicing agreements also can be an issue which goes to whether the plaintiff actually has the right to foreclose. With respect to physical delivery, there's a lot of law from the Second Department saying that assignment can be by written assignment or by physical delivery of the note and mortgage. I think I've already mentioned it's actually very difficult to prove physical delivery prior to commencement. The evidence that the plaintiff is likely to order may be very unimpressive. Parties executing affidavits often lack personal knowledge. They might not even work for the right entity, and they usually can't provide any kind of specifics. So they typically don't meet the standards for granting summary judgment. I should mention, and this is not, today's training I'm not going to be delving into because there's neither time and I'm probably not the best person to do it, to go into all the nuances and intricacies of the Uniform Commercial Code and what it has to say about how loan notes are to be transferred. But it's fair to say that not all of the Appellate Division and trial court's pronouncements about transfers of notes are reconcilable with the actual requirements of the UCC, and there's some confused language in some of the case law, which we kind of have to live with. But it's not even necessarily the case that physical delivery is going to do the trick if the loan, if the note that's being transferred is not in fact a negotiable instrument. I don't want us to get too bogged down on that because we could go on for a day about that, and it's probably better to talk to people who have more expertise about that than I do. Next slide. MERS, again, just for those who don't know what MERS is, it stands for Mortgage Electronic Registration System. It's a electronic registry that was created by the banking industry in order to facilitate mortgage securitizations so that each time ownership of mortgages changed hands, it would not be necessary to go into the local county clerk's office and file a new mortgage assignment document reflecting the current ownership. So what would happen was when the loan was originated, typically MERS would be denominated as the nominee for the lender and authorized to do the filing, and then the subsequent transfers would take place in a black hole behind a curtain somewhere in the MERS entity without any transparency whatsoever. But as a practical matter, MERS typically never became the holders of the notes, which actually represents the debt obligation, and only became the owner of the mortgages, which on its own is not enough to give them authority to assign the notes. So this was addressed very explicitly in Bank of New York versus Silverberg and many subsequent cases citing it. So that, you know, gives you a pretty strong challenge in many, many cases where you can see MERS in the chain of title, and it's very clear that they were solely there as nominee for the original lender. A recent case where this was addressed by the Second Department just several months ago is this Goldie decision. It's also helpful because it sort of gives you a roadmap of many of the typical issues that we see. In this case, they actually reversed the grant of summary judgment in favor of the plaintiff, and upon a search for the record, they awarded summary judgment to the defendant, dismissing the foreclosure action because MERS was never the lawful holder of the mortgage and note when the action was started. They went through it, you know, in a fair amount of detail. The mortgage language that identified MERS as the nominee and that purported to authorize it to foreclose was insufficient to overcome the requirement that the foreclosing party be the holder of the underlying note when the action was commenced. And the note specifically identified a different party as the lender, and the plaintiff failed to submit any evidence demonstrating that the note was physically delivered to MERS. And the evidence that MERS assigned the mortgage instrument to the plaintiff during the course of the action was of no effect whatsoever, because that could not render the plaintiff the holder of the note, since MERS never had the note. And plaintiff's servicing agent's affidavit stating that the note was delivered to its records custodian during the physical delivery of the note. I kind of think that you can look for in your cases, which give you good bases for challenging findings. The findings of the plaintiff failed to prima facie establish its entitlement to foreclosure. Its evidence of physical delivery gave no details whatsoever, and it failed to prove that it was the holder of the note by virtue of an endorsement or a written assignment where it relied on an undated endorsement that was not annexed, supposedly signed the assignment, was authorized to do so. Again, I highlight this because this is a pattern that we see often, conflicting versions of notes and assignments and endorsements. So it's always really important to look at what the plaintiff alleged in the complaint what they then put forth when they try to move for summary judgment, and often that's right then and there is going to give you a disputed issue of fact. Here's another Second Department case reversing a grant of summary judgment and dismissal of the defendant's affirmative side of things. Court held that the plaintiff failed to establish its prima facie standing because the evidence did not demonstrate physical delivery prior to the commencement of the action, or that it was an assignee by virtue of a written assignment. They didn't go into too much detail about what the evidence was or what it wasn't, but they clearly got the right result. Some of the best decisions that we have are some trial-level decisions, so I've put quite a few of these up here to demonstrate sort of some of the issues. Why are there so many of these cases from Kings County? Well, I think it's fair to say we've been doing a pretty good job educating our judges there, at least some of them. So they've been doing some good work in these cases, and we have some pretty good decisions. Here's a fairly recent one from Judge Schmidt, the Guy case, granting a motion to dismiss for lack of standing. The court was very critical of what was called a possession affidavit that the document custodian offered because it was not based on personal knowledge, and it asserted physical delivery on a date, again, that was inconsistent with the allegations in the complaint. Plaintiff relied on an undated allonge. And I should say, for those who are not familiar with the term allonge, it refers to a separate piece of paper on which endorsements, subsequent endorsements for a note can be written. But the point of an allonge is that it has to be firmly affixed to the note such that it becomes an integral part of it. And we often see these floating around after the fact, unattached to anything. But in any case here, Judge Schmidt noted that the allonge was highly suspicious because there was no reason for there to be an allonge when there was still room for further endorsements on the note itself. Here the plaintiff also came up with a novel theory that the defendant's previous acceptance of a HAMP modification was somehow a ratification of the plaintiff's ownership of the note. And Judge Schmidt just pointed out that he's never heard any authority for that point. And that was just sort of an interesting novel argument that the plaintiff tried to offer. Here's another Kings County decision. This one is interesting for a few different things. First of all, it involved a known robo-signer, and the assignment had been executed by plaintiff assignee's counsel. The assignee is not the person who should be executing the assignment. That's highly suspicious. This was on re-argument. Court rejected plaintiff's argument that the pooling and servicing agreement affected a transfer of the note by physical possession. Again, there was another one of those allonges, also an insufficient affidavit alleging physical delivery. The court rejected the argument that the pooling and servicing agreement effectuated a transfer of the note. I found that interesting only because I found it interesting that the plaintiffs have now started to try to argue that their standing is established on the strength of the pooling and servicing agreements, when in fact there are very often arguments that the pooling and servicing agreement defeats their showing of standing because, in fact, it was noncompliance with very specific terms of those pooling and servicing agreements. So I found it a little bit ironic that in this case that's what the plaintiff was trying to hang its hat on re-argument. Here's another good decision from Judge Pataki in Kings County, where assignment of the mortgage from MERS to the plaintiff, which did not purport to assign the note, was insufficient to confer standing. Again, they tried to use an unauthenticated pooling and servicing agreement or excerpts of it to establish their standing. And here, Judge Pataki seized on the fact that it was unauthenticated, not necessarily on the fact that that didn't actually even establish the transfer. And it also found the affidavit in support of the motion was not based on personal knowledge and failed to establish that the assignor ever had possession of the note. I do have to point out that I shouldn't create the impression that, every time you challenge standing it works. That's not the case. Here are two recent Second Department cases which found that there was standing and that summary judgment or dismissal was not appropriate. The first one is not really terribly impressive. It just sort of recites by rote that the plaintiff established its prima facie entitlement by providing the subject note and mortgage and proof of default without any analysis, just saying that the defendant failed to raise a tribal issue of fact. The Friedman case says a little bit more, but again, it just says the court properly found that defendant waived the standing defense by failing to raise it in its answer. So we'll get to that whole issue of waiver of the defenses, but it also held that in any event the defense failed on the merits because the plaintiff demonstrated that when it commenced the action, it was the holder of the mortgage. It's strange to me that they reached that conclusion because they actually recite some facts that make it sound like there's something highly suspicious here. There were apparently two slightly different versions of the note, both of which were endorsed in blank. To me, this suggests, a classic example of there being a disputed issue of fact. But here, apparently, the plaintiff agreed to proceed on one of them, and apparently the defendant, according to the opinion, had conceded that that one was validly signed and was not altered. I would have obviously reached a different result. But so there is, there's bad case law out there.
Jay.
Here's another one. Was there a question?
Jay, this is Becky. I'm just giving you a heads up. We're about halfway through.
Okay, so I'm probably going to go a little quicker over some of these decisions and let you sort of just peruse them on your own. Here's another one from the Second Department that I'm critical of in terms of it's just reciting that they found sufficient findings of standing. So these are examples from the First Department. And in the interest, I want to actually go back on that one because this Shapiro case presents another wrinkle on these facts where here the plaintiff was able to establish its standing on the strength of a prior decision of the First Department, which basically recognized that J.P. Morgan Chase as the successor to WAMU had standing to foreclose on all those former loans. That was a situation where WAMU was taken over, and then J.P. Morgan Chase went into receivership, and then from the receivership, J.P. Morgan Chase acquired all of those loans. So that is pretty much a done deal, and there are some similar issues regarding IndyMac loans now held by One West. So there are fewer options for challenge, although there still can be options for challenging whether, in fact, the entity had the loans in the first place before they were taken over by the successor entity. Here's some other not terribly helpful decision from the First Department. This presents the issue in a different context where there have been some efforts to challenge judgments that are already obtained based on the CPLR provision that allows you to try to vacate a judgment that was procured by fraud. There have been some efforts to basically argue that a plaintiff who got a default judgment misrepresenting that it had standing to pursue the foreclosure procured its judgment by fraud. This is one of several cases which sort of rejected that. Just to also show you some cases from elsewhere around the state, here's some unhelpful Third Department decisions which up in the Third Department, it doesn't seem like the standing arguments have gotten too much traction, and they've pretty much bought into the notion that if it's not been asserted in the answer, standing defense is waived. So again, I'll try to not spend too much time on this. This third department case was also a little disappointing because it didn't really apply Silverberg, and it decided that the language in the mortgage that had been assigned to the plaintiff or to the plaintiff's assignor was sufficiently broad to encompass a transfer of the debt obligation as well. So third department, at least at the appellate level, law is not so great. Here are some other cases which I alluded to this, where the efforts to get default judgments vacated on the grounds of fraud, where there was basically misrepresentations of fraud. These have not gained traction, at least not at the appellate level. I will say that at the trial level, we've gotten this done on a couple of occasions, although without really generating any written opinions. So here, this is we need to talk about the issue of waiver of the defense. There is a bad law that we have to live with, starting in the MASTROPAOLO case from the second department, which has more or less taken hold across the state, basically holding that the defense of standing, if not asserted in a timely answer or a motion to dismiss, affects a waiver of the defense of standing. They equated standing with capacity to sue for purposes of the CPLR provision that governs which defenses are waived if you don't timely assert them, which is 3211E. MASTROPAOLO is one of those cases where bad facts made bad law. You know, in that case, the defendant actually had appeared by counsel and had answered without asserting the standing defense. So there's a little less sympathy to a defendant who had the advice of counsel and still failed to assert the defense. But MASTROPAOLO is dead wrong because just as a matter of the rules, standing is not capacity to sue. And there's really no reason where the statute, the CPLR, doesn't recite standing as one of those defenses that's waived. Why should you treat it the same as capacity to sue? The case that everybody cites from the first department, the Security Pacific National Bank versus Evans case, for the same proposition, actually doesn't stand for the same proposition, because the issue in that case wasn't an issue of standing. It was an issue of legal capacity. But nonetheless, courts within the first department have, convinced themselves that this is the law there as well. So here's just my pitch for why MASTROPAOLO is idiotic and we should not accept it and just, lie down and play dead in light of it. Its reasoning makes no sense for anybody, but it makes particularly no sense for unrepresented parties who answer pro se or who have no understanding of the issues whatsoever. Doesn't make any sense for a party who fails to answer at all, because that's certainly not a knowing waiver. And frankly, why should we ever want to have a law which says that you can award a judgment of foreclosure to a plaintiff who can't establish that the debt is owed to them? And the analogy that I always like to draw is in a conventional contract situation. If you were sued by someone for breach of contract who was not a party to the contract, you would expect that party to be required to prove that it somehow came into the rights under that contract. But our culture in the foreclosure area is, how dare you make me prove that I have the right to foreclose on this loan? And lenders are resentful about the idea of them being required to establish that they actually own the loans. And I point out that there are different policy reasons for why a capacity defense is appropriately waived, which perhaps doesn't apply to standing. Because capacity, A, has no constitutional dimension. It doesn't go to whether there's it's just a justiciable controversy, and it often relates to ministerial failures that can easily be corrected. In other words, an out-of-state entity that has failed to file its paperwork with the Secretary of State can nunc pro tunc go back and fix that defect. So it's a very different thing than the party who's suing doesn't actually own the rights that he's suing on. A testament to how badly reasoned MASTROPAOLO and its progeny is the length to which trial courts have recognized that it makes no sense and the length to which they've gone to find ways around it. So we've seen trial courts hold that it just doesn't apply at all if there's been no answer altogether. That's not a waiver, so they'll sometimes view themselves as not bound by it. And then, of course, there are judges who acknowledge it's the law. They'll quote it, they'll cite it, and they'll say it's stupid and I'm not going to follow it. And that's what happened in this Finocchiaro case in Staten Island earlier this year. I put the language up there because it's pretty compelling. It says it has become evident in the realm of foreclosure litigation that it would be a miscarriage of justice to continue to treat standing as a defense that can be waived. I should also tell you in good conscience that this is probably not the last word in this case. There's a motion to re-argue in that very case that's on the calendar on Friday, and I don't know whether the court is going to change its mind on the motion to re-argue, but I suspect that this case is going to find its way up to the Second Department, and that makes me a little nervous. I don't think the Second Department is going to be all that thrilled with the judge basically saying I'm not going to follow because it's a miscarriage of justice. But here's another avenue of relief available, at least in some cases. It's very clear that you can, if there's been an answer put in that failed to assert standing, you can make a motion for leave to amend that answer to assert standing. And Second Department has acknowledged that that's appropriate, and in fact, even upon amendment, it has then dismissed cases where it's been established that the plaintiff had no standing. Sharif basically reversed a denial of leave to amend to assert the standing and the denial of motion to dismiss for lack of standing where there was no prejudice to the amendment. That's the basic standard for amendment in general. As recently as last week, I've just added to the slide this morning, so in the copy that got distributed to you, you don't have it, but it's on the screen right now. There's that Cox decision, literally from last week, basically holding the same thing, reversing a grant of summary judgment and denial of the cross motion for leave to amend, where those waived defenses, which were not just standing, in fact, by the way, it included capacity to sue and statute of limitations and other defenses, and the court held that those can nevertheless be interposed in an answer amended by leave of court, so long as the amendment does not cause the other party prejudice. And there are other cases standing for the same proposition. So for cases where a client has put in a pro se answer or another lawyer put in an answer that failed to assert standing, there's good grounds for being able to get the standing defense in on amendment. So I always thought that, even if the defense has technically been waived, you ought to still be able to assert these issues because plaintiff's prima facie case in a foreclosure case requires a showing that it owns the note and mortgage. So you would think that even if there's been a technical waiver of the affirmative defense that would get you the case dismissed, you ought to be able to oppose a motion for summary judgment because the plaintiff failed to establish its ownership of the note. The Second Department in the Delphons case didn't see it that way and held that the trial court incorrectly found a triable issue of fact because that issue was waived. even though that case is out there, I think the argument that you can still oppose a summary judgment because the plaintiff hasn't established its prima facie case is available, and at least one judge in Brooklyn, Judge Saida, has come to see things my way on this, and he's issued a few decisions to that effect. This first one, the Irabobo one, basically held that the defense was preserved just where a defendant put in a general denial because the plaintiff's ownership of the note is an element of its claim. So that was sufficient to preserve the defense. And the court also went on to hold it's not even really a conventional standing or a capacity to sue affirmative defense at all, which is waivable, because it's part of their prima facie case. In this particular case, this was a significant case also on the merits of the standing defense, because this is one of the few decisions where we've actually seen a court get to the point of holding that a violation of the technical requirements of the pooling and servicing agreements defeated the showing of standing. In other words, here the note was acquired by the trust after the trust's closing date, and thus it was a void transfer under New York's trust law, and it also violated other terms of the trust. So this is an important decision on many levels. I haven't checked to see whether Wells Fargo filed a notice of appeal, but I suspect they did. So again, this may not be the last word, but right now this is good law. Here's another one from Judge Saida, basically reaching the same conclusion. So this is also helpful. And here it was, he relied not so much on a general denial, but there was a denial of the actual allegation in the complaint that the plaintiff was the owner and holder of the note. And again, this gives you some of the flavor of, the kind of things that plaintiffs do when they try to get their summary judgment motions granted. Here, they tried to establish possession by a servicing agent who had no personal knowledge. There was no proper endorsement, and it was not a note that was capable of being transferred by mere physical delivery because it contained no endorsement. Also, there was a purported allonge that showed up with the plaintiff's moving papers that was not affixed to the note. It was a separate piece of paper. So again, it highlights the issues around allonges.
Jay, while you're pausing, Jay.
Yes.
So first of all, we've got about a little less than 15 minutes, and we have one question that's sort of, I think, helpful for the base understanding of this. The question is there a legal or a theoretical distinction between owning the note and holding the note?
There are distinctions. For purposes of today's discussion, I'm not getting into that, and I don't want us to get bogged down by those UCC nuances. So if you'll bear with me, I'm going to defer on that, and there are people better qualified than I am to talk about that. There are distinctions, and in individual cases, it could impact, how you want to frame your standing defense. But in the interest of keeping this, a workable presentation, I don't want to get into that, if that's okay.
Sure. Okay, thank you.
And if people want to reach out to me offline, we can talk about that, and I can direct people to helpful authorities on that subject.
That's the only question.
So, another question? Okay.
No, I said that's the only question so far.
Oh, okay. All right. So here's another Saida case I put up on the screen where he also, he decided, this was even in a situation where it was an ex parte application for an order of reference, and he still went in and reviewed everything, and again, there were two different versions of the note, one of which included an allonge, and there was a purported Meritorious assignment, all of the different factual issues, and he did this even on an ex parte application. Now, I'm going to be getting to this later. The Second Department has really come down hard on judges on their own, sua sponte, deciding not to grant motions for default judgments and summary judgment, unopposed summary judgment motions based on that kind of inquiry. So again, this may not be the last word from Judge Saida on that, but I also do have to say that there are people who don't practice in Brooklyn on this call, obviously, and some of you may be unfortunate enough to practice in Suffolk County, where we have Judge Whelan. He has said the exact opposite, and even often in dicta, and it's not important to the decisions he's reaching, but he has gone out of his way to hold very explicitly that standing is not an element of plaintiff's claim. For every judge we have who's getting it and is sort of issuing thoughtful decisions, we have judges who are ideologues on the other side as well. I think we need to keep educating our judges on these things. Another area where you can sometimes get standing into the case where it might have otherwise not made its way into the case is it can be found to be the meritorious defense that's required to be shown when you are moving to extend the defendant's time to answer, or for applications to vacate a default and extend the time to answer. And there are a few examples, even from the Second Department, recognizing, and those decisions are hard to reverse because the judge does have a fair amount of discretion. If you can persuade a judge to let you get standing back into the case that way, that can work. Here I mentioned before, Second Department does not take kindly to judges on their own when there's been no assertion of the defense and they view it as having been waived. They don't think it's appropriate for the court to make its own inquiry because it's not jurisdictional in their view. In this particular case, the Second Department really smacked down Judge Shack, who, as many of you know, has been doing this for ages, and rendering very colorful opinions, mostly in unopposed cases. Very rarely did you see Shack issuing a decision in a case where there was a lawyer on the other side. And he did lots of factual research, and for a long time we viewed him as a hero. And when I used to do this PowerPoint with this presentation, a couple of years ago, it was great prominence given to Judge Shack's decisions. Not so much anymore because he tended to really irritate the Second Department, partly because he would disregard their admonitions that he can't be dismissing with prejudice for these kinds of issues, and second of all, because they've been telling him now for a long time, you can't do this if it's unopposed and the defense has been waived. Nonetheless, his opinions make for enjoyable reading, but they're so fed up with him that when they remand with an instruction that the case be assigned to another judge. Okay. If we're talking about standing and robo-signing, obviously we have to mention the fact that in response to all the media attention that was drawn to this a couple of years ago, at this point about 3 years ago, the judiciary was somewhat embarrassed that they had been for years more or less facilitating fraudulent foreclosure filings and indulging or enabling this kind of stuff, which none of this was new to those who've been practicing in this area, but they nonetheless felt the need to take some action, and they came out with the affirmation requirement requiring plaintiff's counsel to file an affirmation certifying that they took reasonable steps to verify the accuracy of the documents. Of course, they didn't require that this be filed at the time the action was started, but only when the request for judicial intervention form was filed. And of course, the plaintiff's firms decided to just not file those requests for judicial interventions, That, of course, led to what we know as the shadow docket and all these cases that got started, and were sitting there in limbo and not making their way into the settlement conferences. Gradually, they sort of started to file the affirmations, but again, in response to bringing attention to the fact that I'm getting ahead of myself. I should point out, while we're talking about the attorney affirmation rule, again, Judge Whelan took it upon himself to hold it unconstitutional for the court to require plaintiffs to confirm the accuracy of the pleadings that they're filing in court. He did it more or less in dicta in a case, and when the Second Department affirmed him, they affirmed him on different grounds, basically on the grounds that the absence of the attorney affirmation in that particular case was not grounds for denial of summary judgment, because the rule wasn't in effect when the motion for summary judgment was made. So the fact that the attorney affirmation got submitted on reply papers was not prejudicial, because it was not really evidentiary. And they, in affirming him, without even mentioning the fact that he had held that the attorney affirmation rule was unconstitutional, just said that everything else that was argued was dicta. So they didn't really address the constitutionality. But there have been many decisions which have assumed that there was nothing impermissible about that rule itself. But in any event, in the meantime, in response to the fact that the attorney affirmation rule was not working when the affirmation was tied to the RJI rather than to the summons and complaint, a certificate of merit bill was passed this past summer, effective as of August 30th. Hopefully most of you are aware of that now. Counsel are required to sign a certificate certifying that they've reviewed the facts and that plaintiff is currently the creditor entitled to enforce the rights of the loan, and requiring that they file with the complaint, if it's with the certification, if it's not attached to the complaint, copies of the mortgage and note and any assignment documents. So that should at least get the facts out about this stuff right at the outset. It remains to be seen how that's going to be enforced and how it will, how the plaintiff's bar will try to find a way of complying with this. We haven't seen too many new complaints come in with this yet, so we'll see.
Jay?
Also, yes?
So we have less than 5 minutes left, but I wanted to make sure there's one question got addressed, very nuts and bolts kind of question, which you know I love. If defendant didn't submit an answer, and after settlement conferences, it is shown the plaintiff has no standing, should the defendant make a motion to file a late answer first, or can they move to dismiss without filing an answer?
Although different courts will handle it differently, I would say that the safest course would be a motion to file a late answer, which would assert the answer, and also, you know, a motion to dismiss. It can be one motion, because I would have some concerns that at least some judges would say, well, this defense isn't even in the case. How can I dismiss on that basis? It's been waived. Whereas if you get the, if you get the leave to put the late answer in, and the defense is then in because the court has allowed it in, but it can happen simultaneously, the same way that on amendment, then the court can consider the motion to dismiss. So that would be my instinct, but there are probably some judges who would let it slide, but there are other judges who would very strictly, I think, just deny it altogether.
Yeah, I can certainly say in Monroe County, the expectation is that you file the motion and request permission to submit a late answer, and then you raise it.
Right. Yeah, that would be my instinct.
Okay, go ahead.
So again, just alerting to you, if we're talking about standing again, there's a specific pleading requirement for loans that are subject to banking law, 6L and 6M, high cost and subprime loans. Is actually a requirement that the plaintiff plead ownership of the note and the mortgage. So that's, again, something to be aware of for loans that are governed by that. That's you want to be looking for whether they actually have those allegations in their complaint. Again, I mentioned capacity to sue. I'll just breeze through this, but a foreign entity that's not authorized to do business in New York can't bring a lawsuit in New York unless they've filed a certificate of doing business. So this Sutton funding case was an example of a non-bank. There's an exception for national banks. They don't have to comply with that. So if you have a lender that's not a bank, some of the hard money lenders or other entities that you sometimes see, that can be a defense that you have, and this is an example of that getting the case booted. But be aware that that's strictly a capacity to sue defense, and that really is waived under operation of the CPLR. I also just want to mention, this is not a settlement conference training, but I think that it's really important to mention that, you know, if you have a case with standing issues, this is an appropriate subject for discussion at settlement conferences and should be on the table. It should influence what the plaintiff's willing to do. We don't see that necessarily in real life, but as a practical matter, you know, we should be negotiating on behalf of our clients with the parties who actually have the authority to do that. Is someone negotiating with you in good faith if they're not even willing to give you assurances that they're authorized to modify the loan on behalf of its owner? Remember that 3408 itself, the settlement conference law itself, states that, you know, the subject of discussion at settlement conferences are the rights and obligations under the governing loan agreements. So to say that you're not allowed to talk about standing in settlement conferences is really kind of ridiculous. We will see, even though it's prohibited by both HAMP rules and by New York State Department of Financial Services regulations, settlement agreements where plaintiffs try to get the borrowers to acknowledge that the plaintiff has the right to foreclose, that's violating those provisions that make it impermissible to condition loss mitigation on waiver of defenses. So you want to be aware of that. And here's a recent case, again from Brooklyn, addressing this issue specifically. This was addressing a motion to confirm a report and recommendation which found failure to negotiate in good faith, where the referee was addressing the plaintiff's lack of standing. And the court noted that, you know, even though the court couldn't dismiss the foreclosure because the standing defense was waived, he said it does not follow from that a waiver of the defense of lack of standing has no place in the mandatory settlement conference process. And in fact, given the fact that the plaintiff is obligated to appear with authority at settlement conferences, it's really central to the discussion. You know, as he says, nothing would be more useless, if not harmful, to the statutory purpose to help the defendant avoid losing his or her home than settlement discussions with a person who does not have the legal right to make the modification or other workout options envisioned by the statute. So we can't ignore standing in the context of settlement conferences. So that's my last slide. I didn't come up with some pithy concluding slide, but I guess my parting words are, these are important issues. As a practical matter, this is probably the defense that we litigate the most in these cases. We mostly litigate it defensively on summary judgment motions. We sometimes do it offensively. I urge you to sort of look at your plaintiff's cases carefully, because there's often a lot to challenge, and there's good case law out there to try to educate your judges. And you know, we can do some good things for clients with this defense. So I consider it, you know, the most important defense we have to work with these days. More questions?
That's all I have right now, Jay.
Okay.
So, Jay, thank you as always for your information and your wisdom on these topics and your thorough analysis of the case law out there. We do have a CLE code that Michelle has put in the chat window of your little dashboard there. So if you have any additional questions, you're welcome. You're welcome to reach out to me, I believe, or Jay. Is that correct, Jay?
Sure.
So thank you, everybody, and thank you, Jay, again.
My pleasure. Thanks so much.
All right. Bye-bye.
Bye.